by hearing involving disputed issues and material facts. There will be two tabs on that agenda: disciplinary cases, in which I have to recuse myself due to my participation in the Probable Cause Panel, and I'm going to appoint temporarily chairmanship of this board to Dr. Aufderheide, who will take on that task. With that, just a symbolic gesture.
Good morning, everyone. My name is Leland McCarran. I'm the prosecuting attorney for the board today. And the first case before the board this morning is Department of Health versus William Kale, Ph.D. Case number is 2011-04373. As Dr. Orta has said, he is recused from participation in the case today because he was on the Probable Cause Panel. The facts in this case are that on or about June 10, 2013, the respondent, Dr. Kale, was convicted of 2 counts of healthcare fraud in violation of Title 18, United States Code, Section 1347, in the District Court, the U.S. District Court in the Middle District of Florida, in the Tampa Division. The case number there was 8:11-CR-115T-30MAP. Now, in this case, the administrative complaint alleges, instead of counts, one simple violation, that Dr. Kale is guilty or has violated Section 490.0091W of the Florida Statutes, which is the Board's Practice Act, which states that it is a violation and subject to discipline for any violation of this chapter, Chapter 456, or any of the rules adopted pursuant thereto. And in this case, the violation that's charged is a violation of Section 456.072, subparagraph 1, subparagraph II. And that is being convicted of or entering a plea of guilty or nolo contendere to any misdemeanor or felony, regardless of adjudication, under 18 U.S.C., and there's a long list, but under 18 U.S.C. 1347, which is the very section that Dr. Kale was convicted of 2 counts in the federal case against him. And these are relating to the Medicaid program. Now, on or about October 14th, 2013, the respondent's attorney submitted an election of rights form requesting a formal hearing before the Division of Administrative Hearings, alleging that there were disputed issues of material fact in this case. The department disagreed with this characterization and disputed, among other things, that was put before the department was that whether the respondent had been convicted of a crime, as there is an ongoing appeal of his case. Case law shows that the administrative disciplinary process need not be delayed during the course of any appeal by someone who has been found guilty in a criminal trial. Other issues that were disputed by the respondent, the department did not see them as issues of material fact in this case. The only material fact in this case is whether or not the respondent was indeed convicted of crimes under one of the enumerated statutes that are set out in Section 456.072, subparagraph 1, subparagraph II. And therefore, given the duty imposed on the department by Chapter 120 to carefully review every petition for hearing that comes in and to make a determination whether or not there is a sufficient issue of disputed material fact to warrant referral to the Division of Administrative Hearings, the department then submits this case to the board as one involving no disputed issues of material fact. Again, specifically given that he was convicted of a crime specifically indicated in the statute as alleged in the administrative complaint. At this time, the department would ask that the board make a finding that the respondent was properly served and is entitled to only an informal hearing in this matter.
So moved.
All in favor, say aye.
Before you begin, Ms. Gallagher, did you want to make your appearance for the record? And we need to have Dr. Kale sworn in.
I'm Julie Gallagher with the Tallahassee office of Akerman.
You don't want to swear in.
And here on behalf of Dr. Kale, and Dr. Kale obviously is here and will be sworn.
Would you raise your right hand? Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
I also
Is your microphone on?
No. My mother always said she could hear me just fine. Anyway, so I don't want to overwhelm you. Also, just in regard to the informal hearing, we don't have any dispute or issue with the informal hearing. There was, initially in the early stages of the case, there was some either miscommunication or just misunderstanding on my part that the charge was going to be having been convicted of a crime related to the practice of psychology or the ability to practice, and that would obviously have disputed facts. This is a newer statute and a simpler charge, and so there aren't any disputed facts.
Thank you for that, Ms. Gallagher. I'm sorry, Dr. Arndt.
That's correct. The motion's been made. All in favor, say aye.
I'm sorry, would the motion be restated one more time, please?
You restate the motion.
Yes, the department would request that the board make a motion that the respondent was properly served with the administrative complaint and is entitled to an informal hearing.
Motion has been made.
I'll second.
All in favor, say aye.
Aye.
All opposed, say no. Motion's passed.
Based on that, the department would ask that the board make a motion to adopt the findings of fact as set out in the administrative complaint.
So moved.
Second.
All in favor, say aye. Aye. All opposed, say nay. Motion is passed.
The department at this time would ask that the board entertain a motion to adopt the materials under tab 1 and any addendum material into evidence in this proceeding.
So moved.
Second.
All in favor, say aye. Aye. All opposed, say nay. Motion is passed.
And the department would ask that the board adopt the conclusions of law as set forth in the administrative complaint and find that this constitutes a violation of the Practice Act.
So moved.
Second.
Before you vote on that motion, it would be appropriate for the respondent and his counsel to address the board if they have any questions or issues with the legality of the findings of fact in the administrative complaint.
Not really. That sounds like a lawyer answer. The facts, the underlying facts in this case occurred back in 2007. The statute, however, was passed, I believe, in 12, and so there was some question about whether or not the statute could have been applied, but the trigger really is the conviction, and the case law is unclear, so we really don't have any argument on law.
Thank you. You can proceed with the vote.
Okay. And again, the department is asking that the board adopt the conclusions of law set forth in the administrative complaint and find that this constitutes a violation of the Practice Act.
So moved.
Second.
All in favor, say aye. Aye. All opposed, say nay. Motion is passed.
Now, at this time, it would be appropriate for the board to hear from the respondent in presentation of anything regarding either a misinterpretation of law or mitigation as to penalty or discipline in this case.
Thank you, Mr. McLaren. Before proceeding, I'd ask the members of the board to withhold their questions until the respondents had full opportunity to explain the written and or oral mitigation factors. And we'll have discussion and we'll have questions that can be answered. There's also a complainant in the audience, I believe, who wants to be heard. Again, I request the board hold their questions until that presentation is completed also. You may proceed.
Thank you, Mr. Chair, and thank you, members of the board. I also have here with me Lori Cleary and Patrick Donahue, who are members of Dr. Kale's criminal defense team and participated in a 3-month-long federal court trial. So if there are any questions that are more particular about the case, they would be better suited to answer those, having lived with this case, very intimately for the last few years. As you saw from the materials, your guidelines in a case of healthcare fraud obviously call for revocation, but you can also impose and lesser penalties and deviate from that. And we've argued, I hope convincingly, that the penalty here should be an indefinite suspension until the case is resolved on appeal. We believe that Dr. Kale's professional life is one worth saving and hope that we can convey that to you as well. As we've said, this is a fraud case unlike any other fraud case. This is not a case of upcoding. This is not a case of billing for services you didn't render. This is not a case of prescribing unauthorized services or unnecessary services. This is a case about corporate reporting obligations under a multi-million-dollar contract with the Agency for Healthcare Administration. And those reporting obligations under the 80-20 law were very vague, very unclear. Nobody at ACHA knew exactly what was required, and nobody everybody obviously in the managed care world knew exactly what was required. You know, obviously there seems to have been a determination by the judge and the jury here that the management at WellCare made a decision to try to do everything they could to avoid having to refund any money under their obligations under that contract. But the facts are, with Dr. Kale, that Dr. Kale had no role in the 80/20 reporting, the compiling of the information, the authorization of the reports. He didn't sign any of the reports. There were 20 people above him at this multi-billion-dollar corporation that had a bigger role in the preparation and authorization of those reports. And certainly the plan or the scheme and how the subsidiary company would be formed was not Dr. Kale's making. That came from the top. Dr. Kale's role was a clinician. He was charged with developing the network, and develop it he did. They expanded the network to serve from 60,000 members up to a total of 750,000 members. He was focused on hiring and credentialing qualified clinicians. You might say, well, why did he go to work for a managed care company at that stage in his career? Because as you've seen, he had a very successful career, very committed to the profession and his community and obviously his family. And I think he would tell you that it was because he saw an opportunity with the expansion of managed care into psychology, into mental health services, to maybe make a difference with a previously underserved population. Remember, this was a Medicaid managed care, and Medicaid recipients had often had limited or sporadic access to quality mental health services. And one thing that was clear from this case is that there was never any question about the services, the quality of services, the psychology services that were rendered, the psychological services that were rendered. And also, we talked about Dr. Kale at some point pushed for more transparency in his discussions with ACHA. And you might want to know, well, why didn't he leave? Well, I can tell you that there was a lot of confusion about the 80/20 law, and also that they were surrounded by a team of experts. One of those lawyers they hired was the former director of Medicaid. They had all the biggest high-powered law firms looking at the issues. The CEOs and the management team themselves were all, Ivy League MBAs, assuring Dr. Kale that, he didn't have anything to worry about. Everything they were doing was legal. Just focus on that network. And again, that's what he did. We've outlined, the several mitigating factors that you have in your rule, and I won't go through all of them. I think a few are worth mentioning. The danger to the public. There's no danger to the public here if Dr. Kale is given an indefinite suspension while his appeal is running its course. Even the judge said, and I think you have that transcript, that this was an aberration, that these, obviously the men have suffered greatly for what's transpired. The length of time since the violation, the conviction is recent, but the conduct was back in 2007. And again, Dr. Kale didn't sign those reports, didn't have anything to do with the preparation of them. He's had a 30-year career of providing good service. I mean, and that's really an understatement. Stellar service to his clients, to his community. You saw the letters that were written for the federal judge and obviously taken into account. There were 81 letters. We only gave you 19. We just didn't want to, overwhelm you. But I think those letters really detail the kind of person Dr. Kale is and the kind of life that he's led before this. And it seems that those 30 years ought to count for something. As for the appeal, people come and say, well, it's on appeal, that things could change. Well, in this case, that appeal it's a real deal. The federal judge granted Dr. Kale and the other defendants bond pending appeal at the time of sentencing. And I'm not a federal criminal lawyer, but if there are questions, you can ask them more about it. But in order to do that, the standard for him to grant bond pending appeal is that he had to find that there are substantial issues on appeal that could result in either a dismissal or a reversal and a new trial. And to convince a federal judge that the case he just sat on and ruled and made issues on and rulings on for the last 3 months may have raised issues, substantial issues for appeal, where there is a good chance that it could result in an overturning or a dismissal of the charges, is quite an achievement. And he did that without any hearing, any special hearing or proceeding. He made that decision right at sentencing. So I think the judge understood that for Dr. Kale at least, the conviction for him, the jury struggled, they dismissed, or they convicted on 2 counts, and the others were either dismissed or not guilty. So you've heard the term like a split verdict or just a compromise verdict. That may be what it turns out to be. There's no downside here to just suspending him until this case is resolved. He hasn't practiced in several years. He couldn't really realistically practice or even volunteer now with a license, given the conviction. So the only answer really seems to be an indefinite suspension, and we hope that his 30-year record, the unusual circumstances of this case, and as I said, there's no downside to him being suspended. You've taken your action. You've made you've made a statement. You're not letting him just go back out into the community and practice while this is pending. You're going to suspend him, we hope, and wait and see, and let him come back to you at the resolution of the case, where you would still continue to have discretion. So, in summary, I can say if there was ever a case that justified deviating from your guideline, I believe this is it. I hope you've reached that same conclusion. Obviously, Dr. Kale is here to answer any questions as he can, or make a statement, and then the attorneys that really lived with the case could provide more light or shed some more light on issues or questions you may have. Thank you very much.
Okay. Just for the record, before we turn to the board for discussion and to hear from the complainant, does that complete your presentation of the oral and or written evidence of mitigation administrative complaint?
Yes.
Thank you. At this time, we'll call the complainant. Please come forward and state your name for the record, please.
This is on? Yes. My name is Joel Voss.
Okay, very good. Thank you. Proceed, please.
Okay. As far as Mr. Kale being so far down the chain of command, and he didn't know what was going on, and he was out of control of the whole thing, you don't have to look much further than the actual indictment itself. WellCare was a company that he was employed by. Harmony Behavioral Health, which he was the vice president of and director of governmental relations, was specifically set up for fraud, Medicaid fraud. How do we know that? Because a whistleblower wore a wire to meetings, and audio and video recorded, hundreds of hours of statements. Now, as far as there not being a patient who was harmed, or a patient that filed a complaint, this fraud ran into the tens of millions of dollars. I'm not even talking about the civil whistleblower case. I'm not even talking about the securities case in which investors lost, I have no idea how much money. But when you take tens of millions of dollars, or over $100 million out of Medicaid and line your pockets with it, and take trips to Germany, Mexico, all over the place, instead of reporting this. He's been in this for a long time. He knows about that 80-20 law. 80% of all the funds that come from Medicaid are to go to program services. That law is directed directly at behavioral health. He knew this. And if I understand Medicaid is very, very complicated and it's whatever, but what's very clear was the extent that he went to. He was one of 4 co-defendants. The extent that he went to carry this out shows that he knows what he was doing. He knew what he was doing. Because, oh, it's all too complicated, we just didn't know. Yeah, he did. That's why they went through all of the hoops and jumps and scheme that they went through. The government actually called it trickery and craft. Back to my point about no patients being harmed. All of those tens of millions of dollars, that would pay for a lot of eye exams, a lot of teeth cleaning, a lot of antibiotics, a lot of well baby exams. That money could have gone somewhere. Fortunately, the government did get the money back, but you can see what they had to do to get it back. They had to do a criminal case where all 4 co-defendants pled not guilty. There was a whistleblower case. They fought that. They knew what they were doing, and if they were to do the right thing, they would have just cut a check and go, "You caught us." That's all I have to say. Does the board have any questions for me?
One moment. Thank you, Mr. Voss. At this point, we'll open up to the board members for discussion and any questions they may have.
Mr. Chair, could I respond briefly to Mr. Voss?
Yes, you may.
I don't know who Mr. Voss is. I believe he represents the Church of Scientology, and, but he obviously doesn't know much about the case. First of all, the indictment is only an allegation, much like your administrative complaint is only an allegation. Many of the facts obviously alleged in the allegation weren't proven. You know what the conviction was for. You know what the judge said. There was no lining of your pockets by Dr. Kale. He wasn't even assessed a fine, which is highly unusual in a case of this. And the judge stated why, he wasn't one that profited greatly from, the return on the stock for the company, or he got a salary, he didn't get bonuses related to the 80-20, but the federal judge made findings that Dr. Kale did not get rich off of, anything that was going on with the 80-20 plan and the creation of Harmony, and that's why he wasn't even assessed a fine. There's already been restitution paid to the government by the company for any claims or any loss to the Medicaid program. And fundamentally, we're just not here to retry the case. I think that while Mr. Voss may think that he knows what happened, that the jury heard the case, the verdict is in, you read what the judge said at sentencing, and let's move forward.
Thank you. I caution the board members that Mr. Voss's affiliation with any alleged religious group is immaterial. Again, board.
Yes, and
for
also,
discussion.
right, I'm actually not with the Church of Scientology. I'm an investigator with the Citizens Commission on Human Rights. It was founded by the Church of Scientology in 1969, and it is quite immaterial. One other thing I would like to respond to is that I never said that Mr. Kale was lining his pockets. I have no idea about his actual pay, but I do agree with his counsel. The jury did hear the case, and he was convicted. The verdict is in.
Thank you. Again, board members, open for discussion. Any questions you may have?
I'd like to hear if there are any comments from Dr. Kale himself this morning.
Good morning, board. I never thought that my career would end like this. I never thought that I'd be here before you today. So that has been quite an eye-opener. Ms. Gallagher mentioned that I was a psychologist for 30 years. I look back on a very rewarding career with many memorable experiences, relationships that I built over the years, satisfaction that in a small way I made a difference, not only in private practice, but in my work at a larger scale, like at WellCare and before that. I recall that the last time I was in Jacksonville, I was here representing Harmony Behavioral Health, the subsidiary of WellCare, and I was meeting with officials from the Department of Children and Family Services to see if we could set up a pilot project for the chronically mentally ill members, the Medicaid members that we were responsible for overseeing in the Jacksonville area. It was called Self-Directed Care Program. And my hope at that time was that we could set that program up and move all over the state with it. But that got deterred at the point that this case all started. That's an example of the kinds of things I did, and really what I was hoping I could accomplish, which was in a small way to represent a large organization in Medicaid WellCare to possibly influence the quality of behavioral health services, not just for private practitioners, but more so for the Medicaid and Medicare recipients that WellCare was focused on. I look back and I realize that I never would have put my career or my family at risk to do something that I thought was criminal or illegal. I never thought that the people who were responsible for this financial reporting with the state were doing anything illegal. I also, myself, knowingly never was involved in doing anything illegal or criminal. I never went home from work at any point thinking that I was part of something that would be tainted the way that it's resulted. Ethically, I've looked at the psychologist ethical standards, and I really can't say that I knowingly felt that I violated even an ethical standard. I knew what my professional expertise was. I was not an accountant or a lawyer. As Ms. Gallagher mentioned, I really entrusted their decisions to be correct ones, and I really was focused on clinical work primarily. And in closing, I just ask for your understanding of what we're presenting here today. So, thank you.
Thank you, Dr. Kale. Any further discussion, any questions? So, in hearing the testimony, what I just heard was that you did nothing wrong. Is that correct?
I'm sorry, sir?
In hearing what you just said, you're saying you did nothing wrong. You didn't know.
I knowingly never believed I did anything wrong.
And yet a federal court of law found you guilty of those two counts.
And I respect the court's decision.
Okay. Any further discussion?
Well, just a couple of other questions perhaps for counsel. Can you give me a timeline of the appeals process at this point?
Lori Cleary, we will be briefing the appeal. Our brief is due September 19th. So this appeal is going forward on a very quick pace, really. It's very proactively handled. Everyone has agreed to the dates, and the appellate court has agreed that this schedule is the schedule that will stay in place. So we anticipate within a year to 18 months that it will be finally concluded.
I'm sorry, for how long again?
Within a year to 18 months, probably sooner, but we can't tell how long it will take to get an opinion. That there's no law or rule requiring an opinion within a certain time from the U.S. Court of Appeals. We are very confident about the appeal. We ask this board not to do nothing. We ask this board to suspend indefinitely, and to revisit when the U.S. Court of Appeals has made its decision. Judge Moody made it very clear, the U.S. federal judge, that there are substantial issues on appeal. We feel that Dr. Kale's issues are the most substantial. And if those issues are seen by the appellate court, as we think they will be, they will rule that he did not have a fair trial, and they will vacate the conviction. And I want to point out that the conviction, a conviction was not had on the lead conspiracy count. There were not guilty findings. There were hung jury findings. We gave you a rundown, really, of what the jury, how the deliberations went. And deep into the deliberations, there was a hung verdict on every count. And that was a very close count. The jury then went away for 10 days and came back and convicted on 2 of the 9 counts. So we ask that this body simply do the appropriate thing, which is a suspension as opposed to a revocation. A revocation would be a permanent, indelible stain on this psychologist's record, this psychologist's hitherto clean record. We think it's appropriate to wait until the court proceedings are completely finalized.
Quick question. There was a request for a new trial, and that was denied already? Is that correct?
There were new trial motions that were denied, but the judge did have to find that some of the issues that were raised on the new trial motions were substantial enough that the Court of Appeals may disagree.
Okay, but that was denied. Second question I have for counsel. If there is revocation of the license, does Dr. Kale have the opportunity to come back if the conviction is overturned?
In this particular circumstance, he would be able to do so because if the criminal conviction, which is the underlying basis of the administrative complaint that led to his revocation, is overturned on appeal, this is a circumstance where the revocation may not be permanent, but he would have to ask the board to vacate that order.
Thank you, counsel. Any further discussion?
Well, again, just to clarify, so again, if his license is revoked today and he prevails on appeal, then the revocation can be expunged from his record?
Well, the order would have to come back before the future board, whatever board is sitting at that time. The problem that you would have, if I may just point out, is if you indefinitely suspend his license today and the appeal is not overturned, his conviction is not overturned on appeal, you don't have the ability at a future meeting to revoke his license at that time. So his license would remain indefinitely suspended forever.
Could I address that? I disagree. And maybe it's just something to request. Maybe I thought I made that request, that we were asking for an indefinite suspension until the case was resolved, at which time he would reappear before the board, and you could decide and have the discretion, depending on the outcome of the case, to make a more final decision, either revoke him, continue the suspension, put him on probation, dismiss. That was what the request was. It wasn't, it was a continuing jurisdiction that he would definitely have to come back and appear before you regardless of how the case comes out.
Well, that really isn't a final order of the board if they're going to come back in the future. Because basically what you're asking is to have this case continued until the appeal is done, because the board can't impose a suspension now and continue the case for a future meeting.
Well, it's sort of like a PRN case where you're suspended until such time as you can come back and demonstrate that you're able to practice with reasonable skill and safety. And so in this case, you're suspended until the case is resolved, at which time you come back to the board and it determines what additional penalties it wants to impose
But you can impose harsher penalties. For example, if you have a PRN case, they are suspended until they can demonstrate they're able to practice, but if they can't ever demonstrate they're able to practice, they remain on suspension. The board can't come back and revoke them. So
but we're stipulating to that they would have the full discretion and the full range of their penalties.
I would advise the board not to do that, because I don't believe that you have the ability to do that.
So again, Ms. Loucks, again, today would be a final finding in this case?
There would be a final order issued.
Mm-hmm. And should we suspend again, and the appeal, he does not prevail on appeal, our final finding of suspension would remain intact?
Yes, sir.
And should we revoke today and he prevail on appeal, then he can petition the board for reinstatement of his license and expunging the record of revocation.
He would be able to appeal to the board to vacate the final order of revocation, and based on the changed and very particular in this case circumstances that the underlying conviction was overturned on appeal.
Thank you.
And again, counsel, this was a criminal case, and so when the jury heard this case, the burden of proof that they applied was beyond a reasonable doubt?
That's correct. We submit that the jury was faced with a lot of difficult issues. They spent 3 months hearing evidence, and we submit that it was a compromise verdict, and really all of the counsel on the case tend to agree on that. However, regardless of our feelings about the case, we do not shrink from the fact that there are 2 convictions, that they were beyond a reasonable doubt. We submit, however, that just as Judge Moody found, there are significant reasons for appeal, This is not a frivolous appeal. This is an appeal that we feel is very likely to succeed.
Thank you. Any further discussion? Any questions for the respondent? Discussion regarding the motion?
Is there a motion?
I don't believe there's a motion.
But no, it's a discussion regarding. Discussion regarding a motion.
Mr. Chairman, the department does have a recommendation as to penalty to the board.
And that penalty is revocation and...
Yes, sir, and there are two specific reasons for that. The administrative complaint charges a violation of a section in your Practice Act that is a violation, as I said earlier, of the Chapter Practice Act or Chapter 456 or any of the rules adopted. Now, that particular statutory section itself gives a range of penalties from a reprimand and a $1,000 fine to revocation and a $10,000 fine, a fine of up to $10,000. But the other statutory section alleged and set out in the administrative complaint is section 456.0721II. And in your disciplinary guidelines, the only penalty that's set out as a recommendation in the guidelines for that particular violation is revocation and a fine of $10,000. And therefore, the department's recommendation in this case basically is simply recommendation. While the fine allowed for in cost, if the department does in fact revoke Dr. Kale's license today, frankly, there's not much leverage to get him to pay. But that's the board's decision to make. That's certainly within the guidelines, and we do have a motion for cost in the case as well. But the department's recommendation today is for revocation.
Let me make clear that the 490 board allows more lenient, the 490 statute allows more leniency, but the section, Florida Statute 456, section 072, that disciplinary is the revocation and the $10,000 fine. Is that correct?
That's set out in the board's own rules, correct, in the disciplinary guidelines. Now, and I'll defer to your counsel on this, but for the board to justify either an upward or a downward departure from the guidelines would require making, as I understand it, Ms. Loucks, making specific findings as to mitigating factors or aggravating factors that would justify that.
Thank you. Any further discussion? I'm in favor of following the recommendations of the department for revocation of the $10,000 fine, which allows the respondent to come back at a later date if the conviction is overturned and appeal for reinstatement.
I would be in favor of the suspension because of the mitigation that was presented, except for the fact of what Ms. Loucks said, that we wouldn't have jurisdiction to ever hear the case again. That is a problem.
So given the fact that we wouldn't have jurisdiction to overhear the case, would you still be in favor of suspension?
If I may, I think she said you'd have jurisdiction to increase the penalty.
Dr. Rubin, excuse me one moment, please. Dr. Rubin?
I'm sorry, I just wanted to clarify. Does that mean that the suspension will remain in place indefinitely?
Yeah.
Correct.
So if the conviction was overturned, the suspension would remain in place?
No.
No.
Well, what Ms. Gallagher's position is the board would be able to revisit the case at a future meeting and remove the suspension and put any other conditions that you would want to put on it at that time. What I'm saying is you could set up the suspension that way. The only option that's not available to you is to come back at a future meeting and revoke his license for not having the conviction overturned. So if you suspend his license today and the conviction is not overturned, his license would remain suspended until he came back to the board, and then it would be up to the board to decide what to do with, with his suspended license status at that time. But you can't revoke his license at that future meeting.
Thank you.
And if we revoke today, again, Dr. Kale can petition to come back to the board and have that finding held in abeyance, withdrawn.
That is correct. He could ask to have that order of revocation vacated.
But if we suspend today, that's a final...
Well, you can suspend him today and retain jurisdiction to have him, have to come back to get that suspension lifted and put conditions that he would need to meet in order to get that suspension lifted. All I'm saying is, if you suspend him today indefinitely, the only condition that you cannot put on him is that you're going to revoke his license at a future meeting. That you cannot do, but you can do anything up to.
So the door is shut essentially to revocation if we suspend today.
Yes, on this particular
Okay.
complaint.
But again, if we revoke today, that can be, again, overturned essentially.
Well, it's possible. It would need to come back before a
His
future
choice to
board.
petition,
But
yeah. Okay.
Dr. Miller, any discussion, questions?
No, I'm in favor of moving forward with revoking the license.
I agree. Anybody else? At this point, the chair will entertain a motion.
I'll move to go forward with the prosecutor's recommendation to revoke the license.
And that includes a $10,000 fine
Correct.
and costs.
And costs.
Do I hear a second?
Wait, can I ask a friendly amendment to that motion? Is it possible to hold the fine and cost part of the motion pending the outcome of the appeal? Or would Dr. Kale then have to start paying the fine and costs immediately?
you can stay, well, if you want to impose the fine, you have to impose the fine today.
Correct.
But you can stay him having to begin paying that until...
Okay.
But that's just the fine. The costs, you cannot stay those, right?
You could stay the costs if you wanted to. I mean, you have to impose them today, but you don't have to require him to pay them.
Okay. Okay. And again, as part of his petition, should he prevail on appeal, his petition could also include then rescinding the fine and costs of this case too.
Since that would be part of the final order, that would be up, they would be petitioning to vacate, it would vacate that entire order. You wouldn't be able to just vacate the revocation and still make him pay the fines and costs if you were to dismiss the administrative complaint.
So I would ask again, Dr. Miller, if the motion could be amended to revoke, to fine $10,000 and costs, but to hold the fine and costs in abeyance pending the outcome of his appeal.
That sounds good to me.
Do we hear a second?
Right, and I'll second.
Okay. All in favor say aye.
Aye.
All opposed say nay. Motion passes. Thank you all.
Thank you for your time. And Ms. Loucks, would you make that clear in the final order that he can come back and apply for reinstatement if he prevails in the appeal?
Yes.
Thank you.
It technically wouldn't be reinstatement since he doesn't have a license, but...
Did I say reinstatement?
You did, but that's fine. I don't...
That the department would ask the board to assess are $906.84. This does not include legal fees in this matter, as legal costs in this are less than $2,000, and it would cost the board more than that to get the expert review needed to justify the cost. So the department would ask that the board impose total cost of $906.84 in this case.
Do we hear a motion?
I move to impose the costs.
As recommended.
Second.
All in favor say aye.
Aye.
Aye. All opposed say nay. Motion passes.
And just to clarify, those costs aren't due to be paid until after the department has received notice on the outcome of the appeal.
Yes, if we need to make that officially part of this motion, then I would ask again for a friendly amendment to hold that in abeyance also.
Hold it in abeyance until the outcome of the appeal.
Can we, just for clarification, say, can you put a time period like within 30 days of receiving notice of the resolution of the appeal? Because, I mean, if you get notice, then does that mean the fine and costs are due the next day? I mean, just as a practical matter, just a time period. And you could set that time period, whatever.
Do we need another motion for that, counsel?
It depends on how you want to set it up. If you say that he doesn't need to begin paying until 30 days after the resolution, that would be assuming that the resolution is that the conviction is not overturned, because I don't know when the conviction of the appeal is going to be resolved and how quickly you would be able to get the matter back before the board. So perhaps you might want to say that they're not due maybe for like 6 months, and that way you would know one way or the other.
Well, if we were going to have to we could come back to the board between that time, between notice of the resolution of the appeal, if we're successful, and possibly change the imposition, the requirement that he has to pay him. So 6 months would give him time to do that. I see the issue.
Yeah.
Because if he's successful, as we hope he will be, then he won't owe them in 30 days, and he probably can't get back to a board meeting within 30 days of the resolution of the appeal, so that makes sense.
So if the conviction is not overturned, then
If you had required it in 6 months, you're basically,
Right.
the compliance officer has to wait 6 months before they,
right, how would the board be made aware of that?
it would be the obligation of the respondent to notify and the compliance officer would also track it since you have put some imposition of fines and costs, but it would be their responsibility to notify the department.
Okay. Do we need to have a motion that the fine and the costs be held in abeyance for 6 months following the determination of the appeal?
Yes, sir.
Do you hear a motion for that?
So moved. Second.
All in favor, say aye. Aye. All opposed, say nay. Motion passes. Thank you.
Okay, thank you.